Hi guys, it's Kathy. I hope you're doing well. Poor Snoopy. Oh, Snoopy, I wish there was something we could do to make it all better for you. So, Kelly, did you Netflix and chill? Is that what you said? Hold on. I'm scrolling up right now because I think Kelly Netflixed and chilled. Wow. Kelly, I, I hope it was fun. Yeah, okay. I binge watch. Good morning, Facebook. All right, I have an idea. So, we need to create a new law. All right? Because we see what happens when we have babies with people we think we love. This happens. This stuff that we're watching happens. So we need a new law. From now on, we only have babies. We're only allowed to have babies with people who we are in a business friendly relationship with. That way, for the rest of the baby's life, there are two parents that get along. Now, the mother and the married couple, they can go have babies with whoever they want. All right? But they can't have babies with each other. Because if you love them, then you can't have babies with them because this happens. Babies should be a business relationship. You need to take a class, is a whole bunch of classes, get certified. You both have to be certified. How about we do like personality, we go to the psychiatrist, personality tests, and you can only have a baby with someone that matches up. This will take care of all the problems. No babies with people you think you love. Don't do that. It'll fix everything. What do you mean? I'm glimping? I'm glitching? Ah, who did you get? This is gonna make a sound for a second. Doing well. Ah, it's stuck. I want to see who Lena's got. I'm waiting for chat to catch up. There we go. You don't have 74 kids. You don't have 74 kids. You might have 47, but Lena's, thank you so much for that gifted membership. That's so nice. Lena's. Okay. I'm scared to press play. Snoopy, go to bed. Go to bed. Bren has 74 kids and he doesn't know any of them. That means he donated to a bank 74 times and he thinks that they were all picked. Yep, 74 baby mamas. Actually, that's even better. No, I like my idea better. We're going to stick with that. Here we go, guys.
And it was discussed at length in court.
Okay. So the first thing is to have him identify exhibit number 1, and if you look at it, ma'am, if it's a document that was previously attached to a motion, then you would have had notice of it from the pretrial memorandum. Okay. You absolutely, you take the time to take a look.
Your Honor, I'm going to object to this first exhibit because I don't have any recollection of it ever being submitted, anything ever. You know, these are screenshots of a phone. Yeah.
Okay. Mr. Lytle, what pleading do you allege that they were attached to?
Attached to our opposition and counter motion. Opposition to motion for temporary primary custody, counter motion for temporary sole physical custody, filed on August 7th, 2018. They were Exhibit A to that particular filing.
All right, why don't you continue to lay foundation while I double check and see whether or not that is the case, or is the clerk doing that? I think the clerk is doing that for me, am I correct, Mr. Clerk? All right, so he is double checking,
Thank you.
and you can lay the foundation.
All right, so have you looked at Exhibit 1?
Yeah, I screenshotted it.
Okay. And could you identify what Exhibit 1 consists of?
It's a text exchange between myself and Karen. And do you know when this text exchange took place approximately? Approximately June of 2018.
Can I object to that?
One moment, the clerk has just indicated that the clerk has compared page by page the proposed exhibit number 1 with attachment A to the pleading, and has, it's A and B apparently to the pleading, and confirms that the documents marked as proposed exhibit number 1 are the same documents that were attached to the pleading in August of 18. Now, you have another objection?
Yeah, I mean, there's no time or date. There's a time stamp, but there's no date stamp. The witness claimed June, there's no date stamp.
Okay, so that would go to the weight to be given the exhibit, not necessarily
There's a
its
date stamp,
admissibility.
Saturday, June 30th, 10:58
One
a.m.
moment, sir.
Okay.
We haven't asked you
All
the
right,
question.
sorry.
All right, Mr. Lytle, if you continue to lay foundation, please.
Thank you. I'd like you to go to the third page of Exhibit 1. Just for identification purposes, at the top in the center it says 8:11 a.m. You see that page?
Which page, sorry?
The third page. At the bottom right corner it says 1 of 1, but there's a few pages that say 1 of 1. So
Okay.
I believe this is what you're referring to at the top of that page. Did you say there is a date stamp?
Yes.
And what does that date stamp say?
Saturday, June 30th, 10:58 a.m.
Okay. And on this particular page, these messages, are these your words or the defendant's on this page?
These are my words.
Okay. So that first entry that's stamped June 30th, can you just read for the court what you wrote to Ms. Sandovaza?
One moment, are you moving now for its admission?
Oh, I'm sorry. Yes, Your Honor. I move to admit Exhibit 1.
Any other objections?
Yes, Your Honor. This exhibit was already dealt with previous in a different hearing. I mean, I don't understand how, what it is they're trying to establish.
I don't know what they're trying to establish either, but the fact that it was attached to a previous proceeding does not prohibit it from being admitted into evidence at this point in time. Generally, I can say that the reason people attach emails and text messages is to show that the parties aren't capable of getting along. But that would be a relevance objection, and what is the relevance of the text messages, Mr. White?
Excuse me, Your Honor. the relevance of the text messages is to establish that essentially shortly after the child's birth, there was a protracted period of withholding of the child from all contact with the plaintiff, as demonstrated by these messages, and then also to establish Ms. Sangalaz's basis that she asserted for that withholding.
All right. The objection is overruled. Foundation has been laid. The exhibits will be admitted.
Okay, so again, Mr. Ravello, if you could read what you wrote to Karen on June 30th.
Can we discuss a time for me to see Julian and what our plans will be for living arrangements, please?
And so why were you asking her that question on that date?
Because I wanted to see my son and figure out where we were going to be living.
At that point, how long had it been since you saw your son?
Weeks.
Was there a response to that message?
No.
What's the date of the next message that you sent?
Thursday, July 5th.
Okay. And what did you say in that message?
Can we discuss a time for me to visit Jay and establish our living arrangements, please?
Okay. And then, was there a response to that message?
No.
So what was the date of your next message to Karen?
Sunday, July 8th.
Okay.
Objection.
And what?
One moment. What's the objection?
Completely skipped the date.
Right. Again, on Thursday, July 5th, I attached a question mark.
And it's not an objection. You can ask if there are parts of this that Mr. Lytle didn't ask about that you want to bring out.
Okay.
You can do that on your cross. Okay.
I don't think she's allowed to see anything until it's put in front of her during the trial. She's not allowed to know anything.
Okay.
So, can I answer that
Okay, Mr.
again?
Lytle.
Yes.
Okay. 2 hours later on July 5th, I sent a question mark.
Okay. And was there a response from Ms. Sangalaza to your question mark?
No.
What was the date of your next communication with?
3 days later, July 8th.
And what did you write to her on that date?
Hi, Karen. Please contact me.
Was there any response to that message?
No.
What was the next communication with Ms. Sangalaza?
2 days later, July 10th. Is your phone working?
And was there any response to that message?
No.
So on this page, we've covered a date period from June 30th to July 10th, and you've testified that this was in 2018, correct?
Yes.
Okay. Did you get any written responses from Karen during that period on any other platforms?
No.
Okay. And did you see Julian at all during that time frame?
No.
Objection.
One moment. What's your objection?
Relevance.
Well, how people get along once the baby is born and prior to the baby's birth is relevant to trying to establish custody, so I'll overrule the objection.
All right. At some point in 2018, did you ask me to file a motion on your behalf?
Objection leading question.
Foundational overruled.
Yes.
Okay. And what was the objective of that particular motion?
I wanted to see my son. I wasn't seeing him at all.
Okay. Do you remember what the result of the hearing of that motion was?
Objection leading question.
No, it's asking him what he remembers, so it didn't suggest what the answer is.
I don't remember.
Okay.
My real name is Bill Henderson.
Are you asking the first?
Objection, witness already answered the question.
Sustained.
Let's jump back. You're the plaintiff in this action, correct?
Yeah.
Okay, do you recall when your complaint was filed?
Objection, question was already asked.
No, he didn't actually answer when the complaint was filed, just a general time period when he saw his attorney.
I know I started the meeting with you in June. I'm not sure the exact date where it was filed to the court.
If you could take a look at Exhibit 2 in your binder, it's going to be behind that second green page. Just tell me if you recognize that document.
I'm sorry, where's Exhibit 2?
Exhibit 2.
The green page? Okay. All right.
Do you recognize Exhibit 2?
The document?
So there's a page, a green page that says Exhibit 2.
Yeah?
Objection.
Right. So the document immediately behind that, do you recognize that document?
Yes.
Okay, and what is that document?
This is our initial motion.
Can you just read the title of the document?
Objection, he's telling the witness what to say.
He's not telling the witness what to say, however, the document hasn't been admitted into evidence. What is number 2? Is it a filed pleading in the case?
Complaint to establish child paternity, custody, and UCCJEA declaration.
Okay. So is that the complaint that you filed to initiate this case?
Yes.
Okay. And in the, on the first page, top right corner, do you see a file stamp there?
Yes.
And what was the date of filing?
June 13th, 2018.
Okay, guys, this, I can't point it out, but this is too much cuteness in one little thing. The dog, oh my goodness, what if your dog's name was Groot? That's too cute, the dog and the Groot. I just can't.
So does
Are you moving to admit number 2, or were you just using it to refresh
I
memory?
was just using it to refresh recollection, really.
Exhibit number 2 is a file stamp copy of the complaint, and the court can take judicial notice of any of the pleadings, that is, that it was a pleading filed. All right.
I think you are. So the complaint was filed on June 13th, 2018, correct?
Correct.
Okay. How long after that date did you next see Julian?
Objection, leading question.
It's not leading, ma'am. He asked him how long. He
Hi,
didn't
Louie,
suggest
Louie,
an
Louie.
answer.
Hi, Louie.
Overruled.
It was around a month. Yeah, I would say at least a month.
Okay. And
Your Honor, may I respond, please, ma'am?
When you have your time to testify, you can then
Thank you.
testify as to what you think he doesn't remember or what he said that you don't agree with,
Okay.
but not while he's testifying. Okay, go ahead.
all right, and prior to the filing of that complaint on June 13th, do you recall when was the last time you had seen Julian?
It had been weeks.
How many weeks? 2?
Objection,
One moment.
he's telling the witness, he's reading the local
I'm
witness.
just trying to get a little bit more
Julius.
specific, Sharon.
I think that A, it is leading, 2, it's cumulative because he already testified in the context of the text messages, a response to that. So I'll sustain the objection is cumulative.
Okay, I believe you testified earlier that that Ms. Sangalaza and her parents had left Summerlin Hospital with Julian, correct?
They did.
Okay, so in total, how much time passed between that time and the next time that you saw Julie?
I didn't spend any one-on-one time with my son until he was at least 6 months old.
Okay. Let me get you to turn ahead to Exhibit 5. Do you see Exhibit 5?
Yes,
Do you recognize the document behind that tab?
yes.
And what is that document?
Partial parenting agreement.
And as you did with the complaint, if you look in the top right corner of that first page, do you see a date there?
November 5th, 2018.
Yeah, I guess I'm asking to admit this exhibit. It is in the record of the case already. As you can see from the file stamp in open court.
Objection? Do you have proposed exhibit number 5, which is the parenting agreement that was filed with the court?
Yeah, actually, Your Honor, I am going to object to it because the orders that Judge Denise Gentile made, they completely overruled this. Actually, no, they were made by Judge Linda Marquise. They completely wiped out this parenting agreement that we have.
So you're saying it's no longer relevant?
Yeah, she made orders.
Mr. Lightoll, what is the relevance?
Yeah, Your Honor, I'm trying to establish a timeline here of contact and when things happen. That's the primary reason for talking about this document. I also want him to confirm the process that led to this agreement and what was agreed to as of November 5th, 2018.
Okay, that attorney just lost a golden opportunity because with her objections, he gets to stand up and say things that he normally can't say. So he could spell out exactly, she never let him see his child. She withheld his child. She withheld his whereabouts. He could say that all to the judge and get it in. And he didn't. He sort of skirted around it and said it too nicely.
With the understanding that obviously that was a year ago and there's more of the story to tell. But I do think it's an important piece of the timeline.
So you believe it's relevant to show the parties' continuing relationships with one another that goes to one of the factors for custody?
I believe
That is, how they relate to one another or what they agreed to?
I believe it establishes an important part of the timeline so that we can talk competently about what has happened in the year since this agreement was reached.
All right, so I do find that it has relevancy, even though Judge Gentile and Judge Marquis later, based upon motions filed by the parties, entered a different order than that of the partial parenting agreement. Some aspects of it may have continued, some may not have, so, but it's relevant towards the interchange and relationship of the parties that led up to the trial today. So, objection overruled.
Thank you. Okay, if you would, I'm going to ask you to just go to the last page first, and then we'll go backwards. If you look on the very last page of the document, page 8. See a bunch of signatures on that page?
Yes,
Okay, is your signature on that page?
yes,
And is the defendant's signature on that page?
yes.
And it looks like signatures for me and her counsel at the time, is that correct?
Both counsel, yes.
Okay, and what's the date on all those signatures?
November 5, 2018.
And if you go back to the very first page of the document, and you see a heading that says legal custody provisions.
Yeah.
Okay, can you read the second sentence under that heading?
The parents agree to joint legal custody of the child named above.
And then can you read the following sentence?
The parents agree to provide each other with the names, addresses, and phone numbers of all medical, educational, child care, and other providers of professional services for the child.
Okay. If you go to page 2, at the bottom, there's another heading that says timeshare provisions. Can you see that?
Yes.
And it's starting at line 25. Can you read just the first 2 sentences of that second paragraph there?
Yes. The father's timeshare is defined as beginning after the father has concluded his court-ordered infant and newborn care class. The father's timeshare is defined as beginning on the first Monday after December 1st, 2018.
Okay. Did you complete the court-ordered infant and newborn care class?
I did.
Did you begin having some visitation with Julian at some point after that?
I did.
Okay.
Hi, Sevo girl. Hello.
All right. Once that visitation began, what was the arrangement in terms of where and how the child was exchanged?
We would pick the child up when it was our time. My time was Monday through Thursday. 2 of the days were 8-hour visits, 2 of the days were 4-hour visits.
When you say we, who do you mean, sir?
Oh, the child's mother and I. When we did our exchanges,
Oh, okay, I see what you mean.
the picking up parent would go to the other's home
Okay.
to get the child.
So do you recall the address that you were going to for your pickups?
No objection, Your Honor, relevance.
I can see where that would be relevant, so I'll overrule. Go ahead.
I was picking him up from his mother's parents' home on Kappas Drive.
And who to your knowledge resided at that home?
Objection, that question was already answered.
He did say that it was from her mother's home. You want to know who else besides?
Correct.
All right.
To his knowledge, who
overruled.
all lived at that house?
Okay. Besides her parents.
Sure, if anyone.
It was the same lineup I mentioned before. The 2 parents and the 2 siblings, Isabel and Barrett.
Did the exchanges, the visitation schedule from November that was agreed to, has that continued without interruption to today?
Objection, leading question.
Overruled.
Has that continued without interruption to this day?
It has been interrupted many times.
Okay. Do you recall the approximate date of the first interruption of that schedule?
The first big interruption was after Judge Marquis ordered 50-50 temporary custody.
Objection, Your Honor. So we're only focusing on the partial parenting agreement over here. I mean, how is it that we've already, have we moved from it?
One moment. The objection would technically be non-responsive, but if you want to rephrase the question, Mr. Lytle.
Okay.
Your question said departing from the parenting agreement. His response dealt with something other than the parenting agreement.
Let me just ask you sort of a different foundational question. Have there been any periods since November of 2018 when visitation by you or custodial time by you was denied by the defendant?
Yes,
Okay.
the very first day.
Okay.
She claimed Veterans Day was her holiday. It was mine that year. So
Objection,
I missed
Your Honor.
visitation the very first day.
Objection, Your Honor.
Go ahead.
So leading question, and then he's pulling things from the air. I mean, there's nothing to back up this claim.
That would go to the weight to be given to his testimony, not whether he can say it. Objection is overruled.
Leaving aside a day here, a day there. Okay, I just want to sort of a yes or no question. Since November of 2018, have there been any sort of extended periods when visitation or your custodial time was denied by the defendant?
Yes,
Okay. And do you recall when the first of those extended periods was?
yes. The first extended period was the entire months of February and March of this year. 2 straight months.
Your Honor, I'm going to object. Are we still talking about the parenting agreement, or what are we talking about?
No, his question was, putting aside a day here or there, have there been times when, extended period of times when you denied visitation? And that was the question. He's responded to the question. So overruled.
Thank you.
You said that was in February or March of this year?
February and March.
February and March. Okay. And what if anything was your response to that interruption of your custodial time? How did you attempt to deal with that?
I was going to pick him up during my ordered times to pick him up. And when he wasn't exchanged, I would call you, my counsel, and I would then contact Metro. And they would come fill out a report card, and I would go home.
Hearsay.
At some point, did Metro advise you that a protective order had been entered against you?
They did, yeah.
Objection, leading question, and relevance.
All sustained is a leading question.
All right. When Metro would make contact with you at these attempted exchanges, what sorts of things did they tell you?
They would typically,
Objection, hearsay.
Counsel?
Goes to his understanding of what it's just to his state of mind. I'm not introducing this.
I'll allow it as to his
as
state of
fact.
mind, not for the truth of the matter. So,
sure, Metro would give me typically a police report card, but one time they did give me news that I'd been served a temporary protective order by her father.
Did Metro facilitate restoring your custodial time?
No,
So what, if anything, did you do next to try to restore your custodial time?
I believe I had my counsel file motions for pickup orders.
And do you recall if the motion for pickup order was heard on the date that it was originally scheduled to be heard?
Objection, leading question.
it's not leading, it doesn't to suggest an answer, so, and it's foundational overruled.
Can you say it again, please?
So you said you had instructed me to file a motion for pickup order, correct?
Mhm.
Okay. And was that motion then set for a hearing date?
I think the temporary protective order filed by her father precluded that.
Objection, witness didn't answer the question that was asked.
I'm just asking if it was set.
Sustained.
It's non-responsive. I'm just asking if it was set, leaving aside the TPO, we're just talking about the motion for pickup order, was that set for a hearing in family court?
I believe so.
Okay. And do you recall if that motion was
You're number
heard,
one.
on the date that it was initially scheduled to be heard by Judge Markey?
I believe,
If you don't remember, just say you don't remember, sir.
yeah, I don't remember specifically the first pickup order, the result.
Do you recall if, after the filing of that motion for pickup order, do you recall whether Ms. Sangalaza filed anything with the court?
Yeah, she filed a motion to disqualify the judge based on discrimination and bias.
Okay. And do you recall what if anything, resulted from her filing of that affidavit
Objection.
of disqualification?
Leading question.
It was not a leading question. The court records are the court records, Mr. Little.
Correct.
What's the point of the question? The motion to disqualify was heard by the chief judge. The chief judge denied the motion.
Correct, which resulted in a significant delay to the hearing of the pickup order, which is,
And you can make that argument asking me to take judicial notice of the records
I'll do
because
that.
I don't think your client is going to be able
That's
to
fine,
come up with information
No problem.
specifically as to each of these.
no problem. Well, let me just ask you this then. At some point, was the motion for pickup order heard?
At some point far down the road, yeah,
Okay, and was the motion granted or denied?
granted.
Okay. And once that motion for pickup order was granted, did you then get Julian back in your custody?
No,
At some point?
Objection, Ms. tell
One
the
moment.
witness what to say.
it took a long time, it took 2 months.
Okay. But I guess my question is, at some point, did you get Julian back?
Yes, I received sole temporary custody.
Okay. All right, thank you. All right, so once you had him back with temporary sole physical custody, what did you do with Julian?
I took him home to Wisconsin to meet his family and friends.
Okay. And how long did you stay in Wisconsin?
About 3 weeks.
Could you just describe for the court what that 3 weeks in Wisconsin was like for you and Julian?
Objection, Your Honor. This attorney is asking the witness to testify on something that's never been discussed in court. I mean, they've never even brought up this experience in Wisconsin. All I knew was the baby was not in the state when I was supposed to receive him.
So your objection's overruled because if you wanted to know what they were going to testify to, you could try and do a deposition beforehand, but the mere fact that it's something new, again, that would go to the weight and not the admissibility. So he can testify as to what the experience was like for him.
My 3 weeks in Wisconsin was like a dream come true. He got to meet his entire network of probably over 50 people who wanted to spend time with him and meet him. We even had a chance to have his first birthday party where over 35 people came and really celebrated his life and my chance to be his dad.
If you would, maybe towards the back of your stack, if you would look at, I'm sorry, it's actually going to be towards the middle. If you look at proposed exhibit 11, it's, should just be 4 pages.
Okay.
Your Honor, I'm going to object to this exhibit. It was never entered.
Number 11.
It wasn't even, it's not in the records at all.
Proposed 11. And what pleading do you represent this was attached to? Because that was your representation that
Right,
each
these are-
of the exhibits had been previously attached.
These are just photographs, and I'm just looking to admit them as a demonstrative, and not for any fact purpose whatsoever.
I don't think they qualify as demonstrative, Mr. Lytle.
Okay.
If they were not attached to a previous exhibit, then I'll sustain the objection and exhibit 4 won't come in.
Fair
Or
enough.
11 will not be admitted.
Fair enough, Your Honor. All right.
He can describe how he felt. You know, that's, calling it demonstrative doesn't get away with the rules, so.
Okay. All right. Let's just fast forward to more recent history. What, in the last, let's say, 4 months, what has been the custodial timeshare between you and Ms. Santalada for Julie?
50-50 on a 2-2-3 schedule.
Can you just explain exactly what that schedule is for the record?
Sure. Mom has him Monday and Tuesday. Dad has him Wednesday
I just ordered coffee. Yay!
and Thursday. And we alternate Friday through Sunday.
And where are custodial exchanges happening now?
Per Mom's request, they are at Metro headquarters.
On Martin Luther King?
Yeah.
All right. Can you describe your home?
Objection.
How many bedrooms, bathrooms, that sort of thing?
Okay,
Objection.
what's the objection?
Relevance.
It's clearly relevant to where the child's going to stay, what kind of conditions the child will live in, so overruled.
I currently have 2 homes, my 2-bedroom apartment here in Vegas and my 4-bedroom apartment, 4-bedroom house in Wisconsin.
The home here in Las Vegas, you said, is a 2-bedroom apartment?
Yeah.
Okay. Do you have any roommates?
No.
Does Julian have his own room in that apartment?
I
Yes.
ordered 4 large.
And has his
Ha!
own bed?
Yes.
And what do you do for a living?
I'm basically a single dad at this point, half the time. The other time I'm a part-time professional poker player.
Do you have any sort of employment that requires you to be at a certain job site at a certain time?
No.
Do you make your own schedule?
Yeah, I'm self-employed.
Objection, leading question.
I'll allow it, again, it's foundational.
What custody orders do you want the court to enter today?
Nan, I'm a server. I don't ever eat or drink hot food. I eat and run, eat and run, eat and run. It gets cold, stone cold by the time I eat it.
I would love to have sole custody of my son.
And do you think that you having sole physical custody would be in Julian's best interest?
I know it would be in his best interest.
Why?
The defendant has made our life a living hell since he was born. She's done everything she can to prevent him from seeing me and seeing my side of the family, all my friends. It's been a nightmare. Whereas it should have been the best thing that ever happened.
I have no further questions of this witness right now.
Okay, cross-examination.
Okay. All right.
Oh my gosh, guys. It's not going to happen, but it's possible at this point. It is still possible at this point that he wins full custody at the end of this trial. He could. They're in trial for it. Let's not get too excited, but that is still possible.
Do you have any other children?
No,
Do you have any siblings?
no.
What do you do for work?
Single.
Objection asked and answered.
Sustained.
Okay. So you stated that you are a poker player, correct?
I did.
And you stated that you make your own schedule?
I do.
And when do you typically play poker?
On weekends.
And so now that we have a 2-2 and 2-2-3 schedule, that requires you to have the baby on weekends. When you're playing on weekends, who has him?
Objection, foundation.
I'll allow it.
I don't work when I have my son.
So what's your source of income?
Objection asked and answered.
Do you have any source of income besides your poker playing?
A source of income?
Mm-hmm.
If I ever needed help, my family would be willing to help me, but that's not a regular source of income, no.
Yes, it
When's
is.
the last time that you filed a financial disclosure form?
Objection, evidence.
Your
I'll
Honor?
I'll overrule it. It's
I
relevant
resemble the title.
to how he's going to support the child and towards child support.
I filled out a form last spring, I believe.
And on that form, what did you list as your source of income?
Objection, document speaks for itself.
Overruled.
What did you list as your source of income on that document?
I believe self-employed professional poker player.
Okay. Your Honor, I'd like to turn to my exhibit, number 10, J.
Okay.
Okay. Do you have it?
Do you have an extra copy there with you?
Yeah,
We can give him the one that the clerk has. if
okay, I
that's
don't have
good.
an extra copy there.
Okay. Proposed Exhibit J. The witness, yeah.
Professional poker player is a thing. There it is. Hi, doctor.
Okay, so do you see Exhibit J?
Exhibit 10?
Yes.
Yeah.
Okay, so what's the date on that email? To the
Tues-
top right corner.
Tuesday, September 17, 2019.
Okay, and then you signed your name on there underneath your
I'm sorry,
signature.
Can we just have a moment of?
It's proposed
That's
J,
valid.
but she had originally marked it 10, not realizing that unless parties agree to the exhibits,
Got it.
she has letters and you have numbers. So first you have to ask him to identify if he recognizes the
Okay.
exhibit, if that's his signature, if it's signed someplace. Then you have to move to admit it, and then you can ask him questions about it.
Do you recognize this email, this document?
Yes?
Okay, and is it signed with your name? Did
Yeah.
you
Yes.
sign it with your name? Your Honor, I'd like to move to have this exhibit admitted.
Okay?
No objection, no.
It'll be admitted.
Okay, so it says Tuesday, September 17, 2019, and your name is signed there at the end of the email. Underneath your name, can you read everything that follows?
Which means out loud, not to yourself.
Vice President of Marketing and Media Relations, Casual Living Outfitters, LLC, 1084 Mapes Drive, Ripon, Wisconsin, 54971, 920-748-9088, www.patiosam.com. Owner, SDH Productions, LLC, 118 East Jackson Street, Ripon, Wisconsin, 54971, 920-896-0006, 801-230-6563, Ravello33@gmail.com.
And did you report these companies in your financial disclosure form?
No, those are my former jobs. I've been a self-employed poker player for 5 years now.
Okay, and then can you go ahead and read again the date that's on the top right corner of this email?
I already read that.
Your Honor, witness is refusing to comply to my question.
Objection
It's
has
not
been answered.
refusing to comply, he's simply saying he already did it. But just read it again, sir.
Tuesday, September 17th, 2019 at 9:54 p.m.
Okay. When you filed your financial disclosure form, did you attach the required bank statements or tax statements?
I haven't earned money from those companies in over 5 years.
When you filed your financial disclosure form, did you attach the required bank statements and tax statements?
Yes.
Your Honor, I don't know what to do because it wasn't attached.
Then you would just, you can move to admit the FDF, you can ask me to take judicial notice of the FDF.
Your Honor, can you take judicial notice of the FDF?
I can, it's a filed document, the one that was originally filed in the case, is that correct?
There's only one, yeah, that they filed.
Any objection to that, Mr. Weigel?
No, Your Honor.
All right.
Okay, so, when did you move, when did you say we supposedly moved to Wisconsin?
Objection has been answered.
Sustained. He said approximately August of 2018.
Okay, and then, so when you said that we moved to Wisconsin, what was your initial request to move?
I asked you if you'd like to move to Wisconsin with me.
Um, that's not,
Well, that's his answer.
right.
So when you take the stand, you can tell your side of the story, okay?
Thank you. So when did you move back to when did I move back to Las Vegas?
You moved back in time for the second semester of college, so early January of 2019.
And when did you move back to Las Vegas? What exact date?
Approximately February of 2019.
Okay, and when you moved to Las Vegas, where did you stay?
For the first 2 weeks, I was playing a poker series, so I stayed at the hotel there while we were looking for apartments.
And when did we sign a lease for the apartment?
March 2019.
And who was on the lease?
Myself, you, and my aunt,
And who
Heidi.
was- And who paid initial fees?
I did.
So did I not pay any fees towards moving?
Objection relevance.
I'm sorry, you have to speak up.
Objection relevance?
What's the relevance about whether you contributed to the fees or not is the objection?
I have other documents that are going to explain like me actually finally moving out of the apartment and why and all of that. And
Okay, but how does the answer to this question, what does it establish in terms of custody or to why you broke up or what the circumstances were?
I contributed to moving into the apartment. I actually lived there, and then he claimed that that it was.
So it's just part of showing the
Yeah,
relationship,
it's
is that
it's
correct?
establishing, yes.
All right, since I allowed him to go into something of that nature, I'll allow her to do it. And then I'll take it for whatever weight when I hear all of the evidence. So the question is, did she contribute anything to the move-in costs? Monetary, is that correct?
When two people sign a lease in an apartment, they both have to pay separate filing fees. She did pay her separate filing fee, which was required, but never any rent or security deposit.
And who paid the rent on the apartment?
Myself or my aunt, because she was feeling quite generous with us having a new baby.
Your Honor, I'd like to please take judicial notice. There was a document that I filed previously at the beginning of, I believe it was July, August, around there. It was a rent ledger document that was filed. And it just shows who,
Okay, so I can't take judicial notice of exhibits that are attached to pleadings
okay,
and the contents contained in them.
okay.
An FDF is an official court document that's required to be filed,
Mhm.
so I can take judicial notice of that because it's used for that purpose of determining child support or spousal support or things of that nature. Just as I cannot take judicial notice of anything that he attached.
Okay.
So if it's part of your exhibits, you can do that. If it's not part of your exhibits, then you'd have the same argument that, well, yeah, I didn't list it in my exhibits, but Judge, it was attached previously. So when you testify, okay?
Okay, so, how many days did I stay in the hospital?
3.
What were those exact dates?
Objection relevance. Objection relevance.
Sorry.
What's the relevance of the exact dates of the hospital stay?
Well, it wasn't 3 days that I mean, in Nevada, they don't, they don't keep moms who had a natural birth in the hospital for 3 days. It's, you know.
You can testify that it wasn't 3 days and it was less than that, or you can produce the hospital record, so that's fine.
Thank you. So you stated the baby was kidnapped, correct?
Essentially kidnapped.
And you stated that I got in the car, correct?
I think I stated that, yeah.
Okay, so, what happened on May 21st of 2018?
I don't recall that specific date.
Okay, Your Honor, I'd like to, move to my exhibit, E.
If you look at proposed E,
It's Exhibit 5?
There's not much 5.
right,
Okay.
I thought there would be more screaming by this point.
okay, can
So
first
do you-
lay the foundation and then you can move for its initial.
So do you, recognize this document?
Yes.
Okay, and then what's the, I'm sorry, Your Honor, I'd like to move to have this document, admitted.
Okay, at the moment you haven't laid the foundation.
Oh,
You just
okay.
said he
I'm sorry.
recognized the document.
Okay, what's the date on the top right corner of that document?
May 21st, 2018.
And what is the document, sir?
The Las Vegas Metropolitan Police Department voluntary statement given by the defendant.
Your Honor, I'd like to move to have this document admitted.
Your Honor, I don't think she's laid the foundation through this witness for this document to be admitted. It's her, I believe this is her statement that she gave to Metro. If she wants to testify about it, it's a different story. but
You're objecting on the basis of hearsay?
I'm objecting on the basis of hearsay and lack of foundation to its admission.
I would agree that you have yet to lay the appropriate foundation, and the second is, it is hearsay. You can testify as to what you told the police, but the mere fact that the police documented what you said doesn't make the police report admissible.
Okay, thank you.
Do you see? Okay, so,
Okay, so on May 21st, 2018,
Is she on drugs or something? She didn't scream and yell. She didn't stamp her foot. She didn't even stand up. What's going on?
was the police called to the apartment on Buffalo Drive?
You probably called the police. I certainly didn't.
And were you at the apartment on May 21st, 2018?
Yes.
Okay, and did the police come to the apartment on May 21st, 2018?
I don't recall.
Were you presently, physically at the apartment or on May 21st? So you stated that you were at the apartment on May 21st, 2018.
Sure.
Okay, and
Would you like to tell me, would you like me to say what
sir,
happened?
don't discuss. We've answered the question, you don't go beyond that. Go ahead.
And so, on that day when you were there at the apartment, who was there, other than the police, I mean?
Objection.
Well, now you're assuming that you were all there together. That hasn't been established. He says he doesn't remember the police.
Okay,
He remembers that he was at the apartment at some point that day.
okay. And then, okay, that's fine. Okay, so then earlier you stated that you hadn't seen your son a month after, you hadn't seen your son for months when you were referencing your exhibit that said June and July, correct?
I said I hadn't spent one-on-one time with him.
Your Honor, can I refresh the witness's memory? He stated that he hadn't seen him for months, when he was pregnant.
You said that at one point, and then at another point, he said he hadn't spent one-on-one time.
Right, so he did state that he hadn't seen him for months, correct? Okay. So, and then you stated also on July 10th that you hadn't seen your son, correct?
In the text message, is that it?
Yes, when he was referencing him.
I hadn't spent significant time with him, no.
But you stated that on July 10th you hadn't seen your son, correct?
Objection. Mischaracterizes the witness's testimony.
I think what he said was that, let me look at my notes. On July 10th, he hadn't gotten a response back to his request to see his son since the June 30th. And then he was asked later on in a separate question, not relating to the text.
Did you have a key to the apartment?
Yes.
And could you come and go as you pleased?
Well, you and your family had basically taken the place over.
Objection, Your Honor, I asked, could he come and, would say, that requires a yes or no response.
Could you get in and out of the apartment with your key?
I had a key, yes, so I could open the lock.
And did you go in and out of the apartment, to anywhere between, when we had.
Beck,
when we
thank
signed
you
the
so
lease
much.
until,
Thank you.
July, end of July. Did you go to that apartment at all, since you signed the lease?
Yeah, I was living there.
Alrighty, and so then, did you ever make a decision to leave the apartment?
I did,
Why?
because you wouldn't move out.
And who was on the lease for the apartment?
Myself, yourself, and my aunt.
And how many bedrooms did the apartment have?
2.
Okay, and when was the lease scheduled to terminate?
Scheduled to what?
Terminate?
April 2019.
Okay, and so you made the decision to leave the apartment on your own, correct?
I first requested that you leave, but then I decided to leave because you wouldn't.
Okay, so in May, how old was the baby? So let's say May 25th, how old was the baby?
Exactly 1 month.
Okay, and so you wanted me to leave the apartment, correct? And where did you want us to go?
I wanted you to live with your parents and me to live in the apartment.
Okay, and then you stated earlier that you said that the baby was kidnapped after he was born, after he left the hospital, correct?
He was taken from the hospital to a place that was not my home without my permission.
And where did he go? To your knowledge, where did he go?
To your parents' apartment in North Las Vegas.
Okay. Okay, so moving on, when did you begin the visitation schedule? The
parenting
timeshare
plan?
parent agreement. When did you actually begin that visitation schedule?
When did I begin visiting with the child?
Mm-hmm.
November or December of 2018.
Is it November or is it December?
It could have been either. I'm not precisely sure.
When were you supposed to begin the visitation?
Well, I believe the order was sent in August 28th, but there was a long bureaucratic delay with getting...
No, I'm sorry. My question was, when were you supposed to begin the visitation?
Again, the order was entered.
No. My question is, what date were you supposed to begin the visitation schedule? I didn't ask
If you
anything about any
recall,
orders.
answer the question.
I don't recall.
Did you not, okay, you know what, Your Honor, can we move back to that document?
Sure. That is number 5. So, sir, if you would turn to plaintiff's exhibits number 5.
Oh, plaintiffs, I'm sorry.
Your exhibits that your attorney prepared.
Right. Got it.
Parenting agreement?
Okay, so. Can you turn to page 2 of that exhibit? Are you on page 2?
Yeah.
Okay, can you read, again, can you read line 25 through 27?
The father's timeshare is defined as beginning after the father has concluded his court-ordered infant and newborn care class. The father's timeshare is defined as beginning on first Monday after December 1st, 2018.
Okay, did you begin your visitation after that defined date?
Yes, of course. It was after that day.
Your Honor, I don't know what to do, but there was an order that was put in previous to this that said that they could begin the visitation before he actually completed the care class.
Your Honor, I'm going to object to Ms. Party testifying to you in the course
I'll
of a
take a look
cross-examination.
at the orders, because again, an order is a document I can take judicial notice of. There certainly was a temporary order prior to the parenting agreement. Whether or not that order was complied with would be the issue. So, but there certainly was a prior order entered by Judge Marquis prior to the parenting agreement having been reached.
Okay, and then after the parenting agreement, there was another order too.
That's very true.
So Kelly, if you paid, let's just say your electric bill was $2,000. If you sent in a payment for $2,000, that would be like a red flag for them because your assistance doesn't give you that much in a month. Is that, or $10,000? It's just a number. I'm just saying, if you paid a number that's more than what the assistance might be, then you could get kicked off.
Have had motions and counter motions in quite a few hearings, and there have been judicial orders setting various custody arrangements depending upon what that particular judge found in the way of facts relating to those motions.
So did you spend Thanksgiving of 2018 with your son? Partially.
If you get packages delivered to your house, is that a red flag?
Did you see him?
I don't specifically recall.
Okay. Your Honor, can we go ahead and move to, well, look at Exhibit D, the
Okay.
number 4.
So that's defendant's D that you'll see in her packet was kind of marked as 4, but it's actually D.
I'm on it.
Okay?
Do you recognize this document?
Is this from Talking Parents?
Yes.
Yeah, I'm familiar with that.
Okay. Your Honor, I'd like to move to have this talking parents record admitted.
Any objection?
I see that the talking parent records in mine appear to be over multiple exhibits. So
Well, we're looking at Exhibit D, number 4.
I have no problem with admitting this. I think we proposed the talking parent records as one exhibit, so
So it may be duplicative of one of your exhibits.
I'm not sure. I don't have
I'll
an
go ahead and
objection, I
admit
don't have
it.
an objection to the admission of the exhibit. I have an objection to the fact that it's sort of arbitrarily been broken into multiple exhibit numbers. That's my only objection.
Okay, so D will be admitted.
Okay, so can you turn to page
I also object to.
8, 9?
I'm sorry. I also just noticed, I object to what appear to be the defendant's handwritten notes on the exhibit as not part of the original document and as hearsay.
Today's has not been crazy at all.
Okay. The handwritten notes, do you have a clean copy without your notes, ma'am?
Did they submit, I don't know what any exhibits that they submitted. They claimed that they submitted the whole talking parents record?
And that's
Okay.
what Mr. Michael says, yes.
Okay.
So I assume your comments are not on, so the court can compare the two, and to the extent that anything's handwritten, the court will
Yeah, we don't have
disregard
to.
anything that's handwritten.
Yeah, we don't have to look at anything handwritten. Okay, can you turn to the page that says 28 of 115? It's about like 5 pages in.
Okay.
Well, and Your Honor, I've also just noticed that it appears in this particular presentation of this record that there is page 18 of 115, and then the next sequential page in the exhibit is page 28 of 115, so I guess I would also, and then after that, it looks like it jumps to page 49 of 115, so I would also object to
Your Honor, may I respond?
Just a minute, he has to
to
finish
the
his objection.
incompleteness of the exhibit.
Okay, go ahead.
Your Honor, I created this exhibit to just show the talking parts. I mean, it is a court record of talking parents. I didn't submit the whole talking parents because I'm not required to. It's just to prove my point and.
I think what he's saying is you're taking it out of context, but that goes to the weight, not its admissibility. Okay.
All right, so on the page that says 28 of 115 right there.
Yes.
Okay, and what's, can you pick any date on there and time and just read it?
Sure.
I'm not objecting
On
to that.
I'll just allow it, Mr.
Fine,
Hunter.
go ahead.
Let me hear it first and then I'll decide.
Sure.
Can you pick any date and time on the page and read it?
Sorry, I was interrupted by the guy in the audience. Sure. On November 12th, 2018, you said,
No, I didn't say any text. I just said a date and a time on the page. Can you read the date and time on the page?
any date and time?
Yeah, not the text, just the date and the time.
There are many dates and times.
Any.
Just pick one.
Okay, November 12th, 2018 at 6:36 and 12 seconds p.m.
Okay. So now, can we look at the one that says November 13, 2018 at 3:56:04 p.m.?
I assume we could look at that.
Okay. Can you read the text that's underneath of it?
I would note for the record that Mr. Sandstone has left the cardboard.
Thank you.
Go ahead.
I'm sorry, which, Which text are you asking him to read?
The third one from the
Wait. Stop. Slow down. All right. So someone help me out here. The father was testifying, and then he said, "I'm sorry, I got distracted by the guy in the audience or gallery." I can't remember what he said. And then the judge just said, "Let the record reflect Mr. Samsung has left the courtroom." Who is that? Is this important? Isn't that just the veterans in politics guy back there? Wait, her dad wasn't in the courtroom though, was he? He's not allowed to be. I thought that was the veterans in politics guy. I don't know. Yeah, he's the veterans from politics guy. Why would the judge care if he left and put it on the record?
top. Can you read the third text from the top that says November 13, 2018 at 3:56:25 p.m.? I'm sorry, no, November 13, 2018, 3:56:04 p.m.
If you don't provide milk, that's on you. I'm going to feed him either way. If you don't give food for your child, it looks bad on you. Formula or milk, you decide.
And then can you read the next following text?
His diaper was never dirty because I had no food.
Okay, so you stated that you began the visitation schedule after December 1st, 2018, correct?
No, I stated that I was visiting him after that date. I didn't recall when it started.
When I asked you, when did the visitation schedule begin, you said after December 1st, 2018, correct?
I said that's what was written on the order, but I couldn't recall if it was November or December of 2018.
Your Honor, I mean, can we refresh the witness's memory?
No,
Did he not say it?
you're talking about which visitation schedule?
The parenting agreement.
Or the parenting agreement, he testified that the parenting agreement visitation would start December 1. But he also testified he had seen his son and had visits with his son prior to that, pursuant to whatever the previous order of the court was, absent the motions about who was denying visitation or whatever was taking place prior to the parenting agreement.
So you saw him prior to,
Excuse me, Your Honor,
Your Honor, isn't it my turn to
No.
talk?
I'm sorry, but in
Go
light
ahead.
of Mr. Sanson's departure, I'm wondering if it might be possible for the marshals just to peek outside and ensure that he is not conversing with.
Your Honor, I'm
witnesses.
gonna object. We're dealing with a matter in here right now.
One moment.
I don't believe he was admonished about the exclusionary rule. I just want to make sure that.
That he can make sure he's not speaking to the other witnesses in the case. That is different. He was subject to the exclusionary rule. With regard to the issue, so if you want to know with regard to the parenting agreement, then it's
Kathleen.
obvious from the
Great
text.
name.
If what you're trying to talk about is when did he, in relation to the previous testimony that he filed the complaint because he couldn't see his son, if that's what you're getting at, then you need to phrase the questions that way. Okay? So he had previously said that he thought that he was entitled to his son on Veterans Day of 2000. Well, he didn't say whether it was 17 or 18, but that he felt that that was, and that you had not complied. So obviously that's before December 1st, 2018. So his testimony has not been that he never saw his son. His testimony was that he didn't see him for a significant period of time. And then he said the one-on-one, which would imply that he was seeing him, he just wasn't seeing him outside of your presence or your family's presence. So I understand that point, but if you're gonna ask him, if you're trying to impeach him, you're talking apples and oranges, so it's not, it doesn't impeach his testimony.
Okay. So were you ordered to file a copy of your completed certificate of the parenting class post completion?
I don't know. I know I completed it.
Were you present in the courtroom when the judge ordered the parenting classes?
Well, the judge didn't order them. She
Well,
asked
actually,
if I was willing.
My question was, were you present in the courtroom when the judge ordered you to take parenting classes?
I was present when the judge
Objections to
recommended
the
it.
Form of the question. And assumes facts not enough.
Were you present in the courtroom when a discussion took place about you completing parenting classes?
Yes.
Did the judge, was your completion of parenting classes later included in an order? Do you know?
I completed the classes and the court was made aware, yeah.
That wasn't the question,
Okay, I'm sorry.
but that's fine. Go ahead, ma'am.
Okay, so you were ordered to file a completion certificate of your parenting classes, correct?
I personally don't know. My counsel handles that stuff.
Did you not just say you were present when there was a discussion on parenting classes?
I was present when the judge brought it up.
Okay.
I wasn't clear on how I filed the certificate after completion.
Not necessarily. Okay, my question was, you were present, you were there, correct? Did the judge order you to file a completed certificate of the parenting class?
Objection, asked and answered.
Sustained, he doesn't remember what the judge specifically ordered. The record speaks for itself.
Okay. Did you ever file a completed certificate of parenting classes?
I showed Judge Gentile a copy of it during a hearing.
Where was the copy of it?
I had a photo on my cell phone.
Moving on. So when we had the parenting agreement, when you went to Kappa Street to pick the baby up, did you ever go inside of the home?
No.
Okay. So you stated that you knew who was living in the home at the time, correct, earlier?
There was an accident, Anthony.
Yes.
So you also stated that you have a 2-bedroom apartment currently, correct?
I do.
Okay, and then did you state at the last hearing in front of Jimmy Gentile that you had a 1-bedroom apartment, and this was on the record?
I highly doubt that. If I did, it was a mistake. It's a 2-bedroom apartment.
Do you have any? Do you have a lease? Did you submit a lease? Did you provide any evidence of the type of apartment that you have, or anything regarding that?
I have a lease.
Did you file one to the court?
I don't know.
Did you ever see those psychology videos where some guy is talking to you and he puts on a completely different shirt in the middle of his talking and nobody notices, and then at the end of the video he's like, and I changed my shirt about 20 minutes ago. Anthony's the only one who noticed.
And you also stated that no one else lives in the apartment with you, correct?
I had some guests this summer, but nobody lives with me permanently.
You stated that no one else lives in the apartment, correct?
Nobody lives there permanently, correct?
Do you often have people who go to the apartment, and do you often have people who visit the apartment?
Objection, league, and relevance.
Overruled on relevance, it is vague. How frequently do you have guests stay at the apartment and for what periods of time?
I rarely have guests over. If friends or family from out of town are visiting, they will stay in the other bedroom.
And they'll stay while the baby is there, correct?
Sure, if it's that time.
And do you have any backgrounds on these type of people? Like, do you know who these people are like that? Might they have criminal records?
Most of them are sitting outside right now.
So my question was, might they have any criminal records? These people, might they be a danger to children? Might they?
I would not allow anybody who was a danger to
Well,
my
my
child
question
to stay at
is-
my apartment.
You're not
Please let him
answering.
answer her questions, Your Honor.
If you would answer the question, the question is, it's improper and it's speculative, might they? The issue is, do you have any reason to believe that the people who've stayed overnight have any criminal records or present any danger to your son?
No, they are only close family and friends.
Um, let's see. So, did Judge Marquise ever order you to change the baby's diaper every 2 hours?
I think she ordered both of us to do that.
Okay. And how often do you change the baby's diaper?
At least every 2 hours.
Your Honor, can we move to one of my exhibits? Can we go to Exhibit H? Which is also Exhibit H. Do you recognize this document, these documents?
No,
So, were they not filed and mailed to your attorney? Did he not share them with you?
I've never seen these photos.
Okay, Your Honor, I filed these as my exhibits and I mailed them to his attorney.
Well, it doesn't mean that he recognizes them. And
Yesterday's was good. She was screaming at the judge. Yesterday's video was amazing.
if they're the black and whites, I'm not certain they're even recognizable.
No, they're color.
Because the attorney, I noticed, is looking at black and whites, but
Okay, I submitted to you guys.
you can identify the photos when you take the stand
Okay,
as to who took them, what's depicted in them, do they adequately represent what's depicted in them. But he says he doesn't recognize them, so.
okay.
And just because you sent them to them doesn't lay foundation that he would recognize them.
Okay. That's true, that's true. Okay. Were you ever notified that the baby were you recently notified that the baby had a diaper rash? Actually, were you ever notified that the baby had a diaper rash?
I was notified by CPS that the baby had a diaper rash because he called them.
And did CPS tell you that I called them?
They said they were notified. I knew who notified them.
Okay, Your Honor, I'd like to go ahead and move to exhibit number, let's see. F, number 6, F. Okay, and then this was also something that I had submitted after we had a change in our judge.
He is the father with 99 point blah 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 percent accuracy.
We had to resubmit our evidence, but I did add on just recent documents.
Like I said, the fact that you attach things to something previously only goes to whether or not someone had notice of the exhibit, but not the admissibility of the exhibit. So you still have to lay the foundation for it being admitted in this hearing.
Bren, there's a camera there too.
So if you attached it to a previous pleading, then whether you actually sent Mr. Lytle additional copies or not, he would certainly have known about the exhibit. That was the same ruling that I said with regard to you. But whether this person the person on the witness stand can identify the document and lay the foundation for it is different. Okay. Just because a document is attached to a pleading doesn't mean it's admissible.
Okay.
For this evidentiary trial. It may have been used as a reason or looked at by the judge in the motions practice in the case.
Okay.
So you can ask him to identify it if he knows what it is. And if he doesn't, then you can try to lay the foundation through yourself or another witness.
Right. Okay. Can you turn to, in Exhibit 6F, can you turn to...
Unless I missed something very important, it's her brother that has an ankle monitor. She lives with her brother who's a criminal and wears an ankle monitor. Not the child.
The document that says... Okay, it says UMC, it's towards the middle of the page, at the bottom. The date says printed on at 9/10/19.
We haven't laid a foundation for
Not,
this document
not yet.
at all.
She's asking him to look at that specific document.
Okay?
I'm sorry, what page? They all
You're
say,
looking at it, it says at the bottom, it says 9/10/19.
They all say that.
Okay, the very first page.
page
Okay.
1 of 10?
Yes.
Thank you.
Okay, so do you know what this document is?
No.
Okay, can you read the top right corner of the document?
UMC University Medical Center.
Okay, what is this document?
Objection, he said he doesn't know what it is.
Sustained.
Okay, the top left corner of the document, what does it say?
After visit summary.
Okay, what is the document?
An after visit summary.
Okay. And so what does after visit summary mean?
Objection,
He
foundation.
can't do that. You're not laying the appropriate foundation.
Okay.
He didn't generate the document. He says he hasn't seen the document. So he can certainly state what's on the document, but you have to lay the foundation. Either it's a document.
Okay, so when a
Okay.
person goes to a hospital, does the hospital give discharge?
Objection. Proper hypothetical relevance.
Okay. He can certainly testify as to his knowledge if he's been in and out of a hospital as to what he might receive. That doesn't lay the foundation for allowing medical records to come in that he hasn't seen before.
Okay.
So in order for medical records to come in, you have to lay a proper foundation. You can either do that potentially with your testimony. You can have subpoenaed the records and have a custodian affidavit, or you can make other arguments as to why it's admissible because the face of the document comes under some provision of the hearsay rule.
Okay. So then I'll
And
wait
with
for
that,
the
I'm
next
going to
one.
take a 10-minute recess. And I would note that you need to think a lot about, both of you, about where you're going because you only have today for testimony. So we'll be in recess for 10 minutes. All right, court is back in session. If you take the stand, Mr. Ravello, and we'll continue with cross-examination.
All right, so do you use talking parents to communicate? Well, did the court order talking parents as the way of communication?
Yes.
Okay. And do you know what are you familiar with the setup of talking parents?
Yes.
Are you familiar with the PDF version of it after you requested to print everything?
Yes.
Your Honor, can we move to Exhibit C, my Exhibit C, number 3?
Okay? It's probably marked 3 in your booklet there, sir.
Got it.
Alrighty, can you turn to the first page?
I'm there.
Okay, are you familiar with this document, or what, do you know what it is?
I'm familiar with the entire Talking Parents record.
Okay. Alrighty, Your Honor, I'd like to move to have this submitted, this exhibit, I believe.
All right.
No objection to its submission, but with the same notes.
Caveat that the personal
There are
notes shall not
handwritten
be.
notes on missing pages. Yes.
All right, same ruling, the court will disregard any personal notations, and this is probably a duplicate of portions of what the plaintiff has in their exhibits, but I'll go ahead and admit it, and that's fine.
Okay, can you look to the heading that says paternity?
Yes.
Under your name, can you read the first message?
Gladly. Stick this in your paternity test.
Okay, can you read your following message?
Gladly. Maybe Steve Sanson is the dad.
Okay. Now, did the court order a paternity test?
You requested one and they
Well, my question is, did
Agreed.
the court order a paternity test?
did.
Alrighty.
That was great.
So were you aware that the baby has been breastfeeding since he was born?
I've never breastfed him. I don't know what you do.
My question is, are you aware that he had been breastfeeding since he was born?
I know you claimed that, but I never saw proof.
Did you ever see me breastfeeding in the hospital?
I don't recall.
Lies, 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 Dad.
Are
Come
you aware
on.
that babies do breastfeed from their mothers?
Objection. Relevance.
I'll sustain it. I don't think he was saying it, and I think the line of questioning is simply, you can testify, it's you know, I think we're just wasting time here. It's clear that you allege that you were breastfeeding. It's clear that there's text back and forth about you've got to give me the milk then. If you don't give me the milk, I'm going to use formula. So, you know, and sir, your responses were not only non-responsive, they were rather sarcastic to say, I know you claimed, but I never saw you breastfeeding. Neither one of you are helping each other here in
Apologies to the
terms of
court,
your
I
claims.
just don't want to participate in wasting time.
You knew that she was claiming that she was breastfeeding and she wanted the child to not have formula, correct? That's what her text messages are to you were about.
Okay, sure.
Is that correct?
Well, I didn't know what she wanted in place of formula. I didn't know what the other options were.
Okay.
Okay, so, did you ever receive a message from me that, told you not to give the baby, any, formula? Because he was solely breastfed?
Very possible.
Okay, and, did you give the baby formula?
Yes.
Do you continue to give the baby formula?
I now give him what's called a nutritional drink, which is for toddlers his age, but I gave him formula before that.
What type of formula were you giving him?
Like a brand?
Yeah, what type of formula? You're the one who gets some formula. What type of formula were you giving?
Enfamil brand formula?
Okay, and what are the ingredients in it?
Objection.
Yeah, she can ask.
I can't name every ingredient in the formula.
Okay. Do you know any ingredient that's in that formula?
I could guess, but I don't have it memorized, no.
Okay. Why did you decide to go with the formula with Enfamil brand over all other companies?
Why did I pick that particular brand?
Yeah, why did you just decide to go with Enfamil brand over other brands of formula?
I read internet reviews.
Did you actually take him to a doctor prior to giving him formula?
I've taken him to a doctor one time, but
My question is, did you take him to a doctor prior to giving him that formula?
I don't recall the order of events. I've taken him to the doctor once.
Okay. Did a doctor prescribe that formula to you for him?
I don't know if babies are prescribed formula, so there was never a prescription.
Well, my question
no.
is, did a doctor prescribe that formula to you for the baby?
No.
Okay. And are you aware that did I notify you that he had a milk allergy to cow's milk?
You claimed that, but never showed proof.
Okay. And do you continue to give the baby cow's milk to this day?
I give him whole milk occasionally.
And whole milk comes from?
A cow.
Okay. Alrighty, and what foods does the baby like to eat?
His very favorite food is blueberries. I feed him a variety of fruits and vegetables, some meats. I try to follow diets recommended
The dad just insulted Fozzie.
by trusted websites.
Okay, have you ever taken him to a doctor to assess his diet to make sure, has a doctor ever recommended a diet for him?
No, when I took him to the doctor, they couldn't recommend
Well, my
anything.
question was, did a doctor ever recommend a diet for him to you?
There are doctors who write journals online and I read them.
Did a doctor specifically recommend a diet for him to you?
No.
Okay. And when you took your parenting class, what ages did it cover?
It was for infant care.
And what age is an infant?
Objection. Relevance.
Relevance?
I'm trying to establish, just knowing how to take care of the baby.
Overruled. You remember the age, up to what age the parenting classes covered?
I think it was up to 6 or 9 months.
Okay, and when you first began visitation, how old was the baby? After parenting agreement, how old was the baby?
About 6 months.
Okay, and have you taken any subsequent parenting classes since then?
No.
Um, Okay, so when you began your parenting class, when you began your visitation, did the judge order you to provide your own food for the baby?
Did the judge?
Yeah.
Well, part of our parenting agreement was you agreed to provide me with
My
breast
question
milk.
was, when you began your visitation schedule, did the judge order you to provide your own food? I provide my own food for the baby. The order, not the agreement.
I believe that was assumed. Yeah.
Okay, all right, so in the same exhibit, can we turn to the page that says 102 of 115? Towards the middle.
I'm sorry, which exhibit was this?
The same one,
Number 6?
C.
number 3.
3? C?
C.
Okay.
Page 102 of 115.
I don't have that page in this exhibit. It ends at 59.
What's the
It's in there. It says page 102 of 115.
I have 12 through 59 here.
So apparently that exhibit doesn't, whatever your copy is and his copy don't agree.
I don't have any following for the record.
Oh, I'm sorry, I'm looking at a different one, I'm sorry. Can we move to my exhibit 2, which is B? Are you on the first page?
Yes.
Okay. So are you familiar with what this document is?
Again, I'm familiar with the entire Talking Parents record, yes.
Okay. Your Honor, I'd like to move to have this exhibit also entered.
I'll admit it knowing that it is not a complete copy of the exhibit and that any handwritten notations will be ignored by the court.
Okay. Can you turn to page 102 of 115 of that exhibit?
Yes.
Okay. So, on that page, can you read the last message?
Sure. I stated, I'll be there at 10:30 a.m. and I suggest you pack a bag with all the food he needs.
Okay. So earlier,
Victoria. Hi, Victoria.
did you read a comment that you wrote that said, "I have no food"? Correct.
Hi, Rose.
I don't know.
Okay, Your Honor, can I refresh the witness memory?
It's another page you want them to look at, or on the
Yeah,
same page?
It was earlier, but yeah, it was earlier.
Then I'm
In
gonna
this-
object to asked and answered.
In this stream? Well, I'm not sure, I mean, does it go with this text, or what's the,
Kind of, yeah.
well, is it all this text, or is it from a completely separate day and separate
It's a
conversation?
separate, no, actually, it's following this. It's November 13, 2018. This comment was November 11, 2018, so it's just.
Okay, so then just say, turn to November 13th, 2018, and what did you say then?
Okay.
Is it in the same exhibit, or is it a different
It's
exhibit?
in a different exhibit that was already in.
Love you, Lori.
Again, Your Honor, I'm not sure what the point of this exercise is. It was, she asked him about a different
Your Honor,
conversation
but
in
it's
a
my turn
different
to do
exhibit.
Just a minute.
cross-examination.
She asked him about a different conversation in a different exhibit. There was testimony about that conversation in that exhibit. It's
Correct.
in the record, it's asked
So-
and answered, so I'm not sure what we're refreshing
So if you-
recollection on.
I don't think you are refreshing recollection, you're asking a whole new question, which you can do, just isn't refreshing recollection. You asked him if at some point previously he had said, that he didn't have food. Well, it's not relevant if his issue is here, and it also can't be taken out of context in terms of
Shit.
what the
Nan,
discussions
are you going to
were
say
with
that?
regard to the food. Are we talking about breast milk? Are we talking about whole food? Are we talking about, starter food for babies? Without reading the entire Talking Parents, taking it out of context doesn't do me any good. So I certainly assume that when he gets back to his case in chief, at some point, he's going to move to admit the entire Talking Parents record. But you're certainly free to ask him to read whatever portions you want to from your exhibits.
Okay. Alright, so, let's go back to Exhibit C, 3. I'm sorry, no, D. Let's go to D4. So are you familiar with what this document is? Do you know what this is?
I think it's already been
Again,
admitted.
I'm familiar with the entire Talking Parents record, so we don't need to keep repeating this.
It's already been admitted.
Okay. So, did you always
True.
come pick up the baby when you were supposed to?
I believe I missed one exchange due to a mistake I made in the schedule
Okay.
on New Year's Day.
Can we turn to page 4 of 115, the very first page of Exhibit 4? Okay. Right under the heading 9/11 morning exchange, can you go ahead and read the message there?
I am unable to pick up Julian today due to flu-like symptoms and physical illness. You can have him today and tomorrow. Let me know if this is a problem.
Was this during your time that you were supposed to have him?
Yes, but since I made you aware, I didn't consider that to be a missed exchange.
Do you believe that parents should take time off from parenting when they're sick?
Yes.
Can we turn to the next page? All right, the very top message. Can you go?
I hate that she just made a great point there. I hate it. I never got to take time off parenting when I was sick.
Go ahead and read that.
I can't make 7 a.m. exchange tomorrow. I can meet later in the day around 4 or 5 p.m. Or the next morning at 7 a.m., which works better.
Okay. Can we go ahead and turn to the next page, 115. Under, can you go ahead and read the first message under Julian updates? Well, yeah, read the first message.
Julian has been great the last few days. He's eating a lot of fruit and drinking a lot of water and juice. He loves climbing on the couch and running, jumping, and playing with his basketball.
The message continues.
I am scheduled to have him Wednesday and Thursday of this week. I'm wondering if you'd like to have him Thursday instead of me, as I have a work trip this weekend. If you are willing, I would drop him off Thursday morning instead of Friday morning. Please let me know as soon as possible.
Okay, so earlier you stated that you create your own schedule, correct?
Yes.
Okay, could you have scheduled around your visitation time with him?
I certainly could have, but I thought we could work together.
Okay, can we turn to the next page? Okay, can you read the second message on the page?
I'm running late today. I'll be there around 7:20 a.m., leaving apartment now.
Okay, and then at the very bottom under parenting situation, can you read the last two messages?
I'll be 10 to 15 minutes late because I was parked in this morning. I'm leaving ASAP.
Okay.
Werewolves?
Perfect. Can we move to my exhibit 9, also I? Okay, do you know what this document is?
Not right now.
Um,
If I read it, I could probably figure it out.
Can you go ahead and read the title to yourself?
State of Wisconsin
No, to
Department.
yourself, to yourself.
Don't read it out loud, read it to yourself. Just read it silently. That's what
Judge, can I move my mouth at all while I'm reading, please?
she's asking you to do.
Do you know what this document is?
I've never seen this particular document. I could probably use context clues.
Okay, and on the document, is that your name and your date of birth?
Yes.
Okay. Your Honor, I'd like to move to have this edited, this exhibit.
He says he's never seen that document, and you haven't laid the foundation.
Okay, can you,
That would be awesome.
no, it's okay, well, I'll pass on that one and I'll use it in my testimony.
Okay, if you can lay a foundation, that's fine. You can also just ask him, is it true, such and such and such and such? You can say yes or no, but
Okay, so, have you ever lived at 333 Tigard Street in Ripon, Wisconsin?
Yes.
Okay, and, okay, on March 3rd, 2016, were you arrested?
Possibly.
Okay. What were you arrested for?
I'm sorry, it's only because I'm not sure the specific date, but around that time, I was arrested for driving under the influence.
Were you visiting
Okay, and
Harris
then,
County?
Also on March 23rd, 2000, I'm sorry, on March 23rd, 2008, were you arrested?
Yes.
I'm gonna
Okay.
object to any questions about anything from 2008. It's more than 10 years old on relevance grounds.
Your Honor, it's still background history of the plaintiff. It's still,
2008 is too stale under the statutes. So I'll sustain that objection.
okay. Back to 2016, so you were arrested and you said it was for driving under the influence, correct?
Yes.
Okay, and so, how often, do you drink?
At that time or now?
At that time, now?
That's,
Which
you
question?
got two different things.
Okay, how often did you drink at that time?
At that time, I was drinking more than I do now.
And what's more than you do now?
Now, I never drink when I'm with my son. That's half the time.
Well, my question is, how
He's about to answer it, and the rest of the time,
The rest of the time, I drink in moderation and in social situations, never at home.
approximately how much is that per day, and what?
Not even one drink per day, maybe 5 drinks per month is an estimate.
And what kinds of things?
I drink beer from Wisconsin.
Okay.
And you find beer from Wisconsin in Las Vegas?
Yep, it isn't particularly relevant, but beers that are manufactured in Wisconsin end up being transported all over. It's just like Coors being manufactured in Colorado or whatnot, so.
Were you ever arrested for domestic violence?
Objection, this is, again, she's trying to sneak in this
Your Honor,
2008
One
conversation.
moment. The
It's
question
established.
is, you need to give something that's relevant to a time period here. Not, were you ever arrested for domestic violence?
Okay, in your adult years, after you became 18, were you ever arrested for domestic
So
violence?
I'm gonna object, he's 34 years old.
I agree, that's not relevant.
You can ask him in the
You
last
can-
10 years.
You can ask him within the last 10 years, because the statute allows that, and actually doesn't even allow arrests, but that's all right, we do allow the question to be asked. And you can ask whether or not it's occurred within the period of time when the two of you have had a relationship.
Okay.
That is
Were
valid.
you arrested on January 30th, 2009, in the past 2 years?
It's not in the last 10 years.
2009?
2009,
January 30th of 2009?
But it's still
Almost
the year.
11 years ago.
It's still the year.
It's not within 10 years, Your Honor.
we're way
It's not
far
within
afield
10
here.
years.
That doesn't show and establish that domestic violence has occurred
Oh, no,
involving
it's not.
you and
This
your
is something
son.
different. This is completely different.
No?
We're getting awfully stale here in terms of this, so no, I'm going to sustain the objection.
Okay, on April 4th, 2016, did you have your license revoked?
Yes.
Okay, when you came to Las Vegas in 2017, did you drive?
I had my license back. It was revoked for 6 months.
Said it was revoked a few
It
times?
was revoked for 6 months.
And why was your license revoked?
Because of driving under the influence
Okay.
conviction.
Okay. Your Honor, no further questions.
Redirect.
Very, very brief.
I just wanted to take you back to Defendant's Exhibit J. I believe it's labeled 10 in yours. It was the email that you testified about.
Okay.
The defendant asked you about your signature there. Did you, when you sent that email, did you hand type all that information into the body of the email?
No, that's my automatic signature that goes on all my emails.
We all want that to happen.
And then, there was a lot of looking at the talking parent record. If you could flip over to our exhibit set and go to Exhibit 12, and just take a moment to go through that exhibit. Do you recognize that exhibit?
If it's talking parents, I recognize all of that, yes.
Just make sure you find it.
Which page?
It's Exhibit 12.
Yes.
I think it's the thickest exhibit in the whole set.
Oh, that'll be
Yes, I
epic.
recognize this.
Okay. And is that the talking parent record communications between the
Your Honor,
record,
objection to.
the record of talking parent communications between you and the defendant?
It's not leading, he's asking you to identify the record, that's its foundation.
Yes, it's the conversation between myself and the defendant.
On the talking parent platform?
On talking parents, yes.
Okay. Your Honor, I move to admit our proposed Exhibit 12.
Any objection?
No objection.
Okay, it'll be admitted.
Nothing further, Your Honor.
Okay. We'll take our noon recess unless you have a very quick witness, which I doubt.
Well, I actually have,
Including cross-examination.
right. I mean, I have 5 witnesses out there that are all probably 10, 15 minutes each, and so we could probably get one of them in if you wanted
All right.
to do that. I will try to pick maybe the shortest of the.
You can
those
step down
5.
and go
thank you.
back to the council table. Leave the exhibits up there if you would, please.
Leave all?
Mhm.
Okay.
Kelly, we're
Sorry,
gonna
I've
break
got them all
in
sorted here.
7 minutes. Then we will break.
Let me just consult with my client real quick about which of these 2 is going to be the quickest. All right, we call Sean Carson.
My streams keep the liquor industry in business. Ghostbusters. I had to. You set it up for me.
Do you just long swear testimony about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, Mr. Carson. Could you please state and spell your name for the record?
Sean Karsten, SHAWN, KARSTEN,
And where do you presently reside?
Ripon, Wisconsin.
Do you know either of the parties in this case today?
I do.
Do you know the gentleman to my right, your left?
Yes.
And how do you know him?
We've been friends since 1992 when I moved to Ripon.
What about the defendant here? Do you know her at all?
I do. I got to know her once her and Nick started dating. And,
Do you remember what year that was that you met her?
I think it would have been maybe late 2017, early 2018. Yep,
And that was, you met her, you said in Wisconsin?
correct.
Okay. Have you met Julian?
I have.
Okay, and when did you first meet Julian?
So I've seen Julian 3 times. The first time was, I think, late summer of 2018 when Nick was back in Wisconsin. It was the first opportunity. I have kids of my own. I had a daughter at that time, and so it was the first opportunity I had to kind of introduce the two of them, which was a cool moment for us.
Objection, Your Honor. Witness is not answering the direct question that's asked.
He did start to answer it, but
Late summer 2018.
Okay. When most recently have you seen Julian?
I think it was for his first birthday party.
Okay. Yeah, earlier this year?
Objection,
April.
leading question. Actually.
was that earlier this year? That's fine, just to lay foundation for a date. It didn't tell him what date it was.
Okay. And have you ever been around Nick and Julian together at the same time?
I have on 3 separate occasions.
Okay. And what are your general observations? You said you're a parent yourself, correct?
Objection,
What are your-
leading
One
question.
moment. Asking him what are his general observations is not a leading question. It's an open-ended question.
What are your general observations of
Objection.
Nick and Julian's relationship?
Go ahead.
Open-ended.
No. It's permissible, that's why it's not leading.
Oh, okay.
It's just ask him to give his observations of the two of them together.
Okay.
So it's not leading. Go ahead, sir, you may answer the question.
My observations was that they had a great relationship. Being a father myself, the first thing that I noticed that Julian really loved Nick, and that they had clearly a special relationship. Personally, it was special for me. I spent a lot of time speaking with Nick leading up to the birth of Julian, and knew how excited he was to become a father. So having those unique opportunities to spend some time with my good friend and my child and his child together was very special.
Do you have any concerns at all about?
Objection, leading question.
We probably are getting into leading now, Mr. Luttrell.
I don't think I am. Can I finish the question and then you can rule?
Sure.
Do you have any concerns at all about Nick's ability to parent Julie?
That's not
I don't see
leading.
how that's leading at all.
He's asking him about any concerns.
No, what he's doing is asking if he has any concerns. Doesn't apply whether he has them or not, so I agree, it's not leading, overruled.
Based on the time that I've personally been around Nick and Julian together, I do not have any concerns in Nick being a father to Julian.
No further questions.
Cross?
Okay. Sean, do you live in Las Vegas?
No,
Okay. When did you arrive to Las Vegas?
last night.
Have you ever been to Las Vegas since the baby was born?
I have not.
No further questions, Your Honor.
Okay.
No redirect, yeah.
All right, thank you, sir. Please don't discuss the testimony that you gave on the stand with any other witness in the case. You're free to leave at this time if you choose to do so.
Thank you.
Okay, now we'll take our
Bobby, that's very nice. Too much coffee is very bad for me.
lunch and recess.
All right, sounds good. What time are we back, Your Honor?
1:30, please.
All right.
Okay, 11/26/19, 1:35 p.m. 4-8. So, she did make that one great point that if you're sick, you still have to parent. I remember I had my gallbladder out, and I lied to the doctors at the hospital and the nurses, and I said, as I had 3 kids, my one was an infant, so he only weighed, I think he only weighed like 20 pounds, okay? But I had a restriction, 15-pound limit as I was recovering. So I told the doctors, oh yeah, I have my mom, And my nieces, everything, they're going to take care of the kids for me. I'm fine. So they sent me home, and I didn't have nobody. I had this towel, which was the greatest thing ever. They gave me in the hospital. Put the towel over your belly where the incision is and just press when you want to move. It worked great. So I was like parenting one-handed. I was picking my son up 20 pounds. Nothing popped. Changing his diaper. And then I had my 2 little girls running around for weeks. And I didn't get a day off. I didn't get an hour off parenting because I was sick or in pain or had surgery or whatever. I would have to be dead. Yeah, oh yeah, those pillows. Yeah, I did lie because they wouldn't have let me leave if I didn't lie to them. And I needed to leave because I had children. I had a babysitter for that day. But, oh yeah, because, so when your belly is in, when you have an incision in your belly, it's just like everything is connected to your belly. If you move your foot an inch, it pulls on your belly. If you grab something with your arm, it pulls on your belly. Oh man, but the towel was great. If you pressed on it, you could do stuff. No, yeah. See, all the parents in here are saying same thing. We all did it. We all did it. So she made a good point. I'm going to give her that one wholeheartedly. Because you can't just take off parenting because you're sick. Because you have flu-like symptoms. What, he sneezed once? Man flu. Oh, wait. Man flu might overrule that. Man flu might be just a bit too much to parent. Okay. Those poor men. Oh, yeah. Yeah. Yes. Yes. All right. We are going to end this stream for the day. It's going to go pop right over into O.J. Simpson. But I am going to play my outro today because we haven't heard it in a while and I miss it. So I'll see some of you in O.J. If not, I'll see you all later. Thank you so much for coming out, everybody. I appreciate it. Hopefully tomorrow we get some real craziness. Bye, guys. Thank you so much.
Got this life that grows digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a wake, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh